All right, we're going to get started, and sorry for the brief delay there. Welcome to this webinar, Examining Haaland versus Brackeen, Understanding the Legal Arguments at the Supreme Court and Their Impact. We're going to get started, and just before we start the webinar, a few housekeeping items. We are recording this webinar, and it will be posted on the CASCW website, as well as emailed out to the attendees. We have enabled automatic captions. Please let us know if you need anything by using the Q&A function. There were over 470 registrants, so we don't have capacity to manage a chat, but there'll be some opportunities for Q&A. We're really going to try to do our best to get to questions, but time is limited, and we want to hear as much as possible from the panelists in our short time. And then for those of you who indicated interest, CEUs will be emailed within a week of this conference. Please note that you'll need to attend the entire event to receive a CEU. And then finally, I'll briefly introduce our speakers throughout this forum, but their full bios are listed on our website. So I'm Stacy Geringer, the Director of Outreach at the Center for Advanced Studies in Child Welfare, and we welcome you today. I'm going to introduce Tracy Laliberty, our Executive Director.
Thank you so much, Stacy. As Stacy said, we are so pleased to welcome you today for this forum, sponsored by the Center for Advanced Studies in Child Welfare at the School of Social Work at the University of Minnesota. As she said, my name is Dr. Tracy Laliberty, and I am the Executive Director for the center, which we also fondly call CASCW. I would like to acknowledge that our university and the land on which we are located for this forum is the unceded traditional, ancestral, and contemporary land of the Dakota people, who are the first people of Minnesota Makoche. By offering this land acknowledgement, we affirm tribal sovereignty and work to hold our university, ourselves, our learners, and our partners accountable to American Indian peoples and nations. We really felt as though this was an important forum to host, to help people understand the legal aspects of what is in front of us. I know many of us come to this forum with our perspectives on the social implications and just the critical importance of what is happening right now in front of the court. So understanding these legal aspects is also critically important, and we are so fortunate to have the esteemed guests that we have to speak with us today. I'm going to turn it back over to Stacy, and she'll begin our introductions.
Thank you, Tracy. So today, first I'm going to introduce Jessica Ryan. Jessica has experience representing tribes for over 20 years as a chief judge, as well as a tribal judge. She's very active in legislative policy analysis affecting Indian families and collaborates with various tribes, counties, and states to develop policy and practice that better serves American Indian families. Jessica is committed to working with Indian tribes and families to help restore balance and harmony. Welcome, Jessica.
Good morning, everybody. Thank you so much for having us here today. We are in support of the importance of this issue that is before the United States Supreme Court, and I'm glad to be with you all today. Just briefly, I am Brotherton Indian, and I descend from the Skeezick and Fowler and Johnson and Abner and Dick lines, and our tribe was forced to relocate. Originally, my ancestors are from the eastern shores of the United States, and I share that because the history of Indian people is unique to each tribe, but we're going to briefly address a little bit of that today in the outset of where we're at. So if I can get, I'm just going to go ahead and share screen here. All right, y'all can see that? Somebody can give me a thumbs up, I'm guessing, yes? This is quahog shells from the eastern shores of the United States. And we're going to jump right in. We have a brief period of time here to talk about federal Indian policy and the history. And this matters to the case that's before the United States Supreme Court, Haaland versus Brackeen. Just ever so briefly, we're starting this timeline in 1492 because that's when settlers arrived here. Obviously, American Indian tribes were here long before that, from time immemorial, and have had a long history of caring for one another, caring for each other, interacting with one another. And all of that predates this first contact of 1492. At 1492 until 1787, this period is generally referred to as the colonial and Confederation periods. Tribes had terrific and sufficient independence during this time. As you all know, folks came to the United States. They were fleeing the government that from their home countries they did not agree with what their home countries were asking of them or expecting of them with regard to religion, with regard to ways of life, with regard to many significant issues. And I say that out loud and call attention to it because when folks arrived here, folks tended to do what they have were comfortable with and what they had known, and they continued to force and expect those kinds of limits on the people who were here originally, the original people. And as you heard from the outset with the land acknowledgement, many tribes were in the United States and obviously in Minnesota long before that. Tribes had a great deal of independence because tribes outnumbered those who were arriving here. There were agreements that were made between the settlers that arrived and the various tribes. They were determined to be equals at that time. And so there was a great deal amount of treaty making and other activities that treated tribes equal to the federal government. Thereafter, we have what's referred to as the removal era or the Trail of Tears. Some people have referred to it as. It's also known as the relocation or reservation movements. There's a lot of different phrases that are used, but they all relate to that period of time where the federal government's intention, the federal government's policy, and it was an outspoken, intentional, written policy, was to remove tribes from their original homelands, push them east, and reserve chunks of land, smaller portions of land, and have the tribe live on that small piece of land that was reserved for them, hence the reservations. That period was generally referred to, it is 1828 to 1887, which is when the Dawes Act was enacted. And the Dawes Act is what commenced the allotment era, and we refer to it as the allotment and assimilation era, 1887 to 1934. During this time period, the federal government's clearly articulated intention was to take those small portions of land that were reserved for reservations and allot them into smaller pieces that would be individually owned rather than communally owned. And the goal was to help assimilate Indians into the non-Indian community. The next general policy era is the Indian reorganization period, and this is 1934 to 1953. And during this time period, the federal government's goal was to help tribal governments form governments. And I air quote that because it seems so funny to me, because tribes had their own governing structure since, time immemorial. And so here the federal government is giving constitutions and bylaws to tribes and directing them that they must complete a constitution that looks like the constitution that they have modeled. And it contains elements in there that the federal government found most critical. One of them specifically was reference to blood quantum requirements, and that an individual would need to be a certain percentage of Indian in order to be considered a part of the tribe. That's not something that historically was a rule, was a way of life in the Indian community, but that was something that the federal government included in the draft constitutions that were disseminated to tribes for adoption. The next time period that's generally referred to from 1953 to 1968 is termination. And during this time period, the federal government did its best to terminate as many tribes as it could. It's not a lot of years here, but there were a lot of tribes that were terminated in this very short period of time. Some of those tribes have restored their status, and many of them have not. There were tribes that were also terminated prior to this act in 1953, this movement, but in 1953, there was a clear intention by the federal government to move forward as efficiently and as swiftly as they could for terminating tribes. Then the last era of policy that's been set forth is 1968 to present, and this is generally referred to as the tribal self-determination era. I take this super fast flyover view just so that we all have this information at the front of our minds as we move into what we're going to be learning and is going to be shared by Karl and by Shannon. 530, why did I put 530 here? That's the math from 1492 to 2022. 530 years, the federal government and tribal governments have been negotiating their relationship. And this is significant for the sum and substance of the arguments that were before the United States Supreme Court just last week. Through that establishment over 530 years of renegotiating that relationship and interpreting what that relationship is, it's clear that there is a unique political status that is bestowed upon each and every tribe that's recognized by the United States government. This authority derives from the United States Constitution. It derives from the Marshall Trilogy. It derives and it identifies this unique relationship that each and every tribe has. So each tribe is its own sovereign. It has its own lawmaking body. It has its own governing structure. It has its own traditions, its own values, its own way of life. Each and every one of those pieces that go to sovereignty relates to each of the tribes that are federally recognized. And it's important to note that this unique political relationship is more than a racial distinction or racial classification. Those of you who've been following along with the Supreme Court case, you know that this was a significant issue that was litigated, but we have 530 years of legal precedent that underscores that unique relationship that tribes have with the federal government, and it goes beyond being a different racial classification. Congress is another source for this authority, and some examples of that, which if you've heard the arguments, you've been able to know that there are special congressional legislations that were enacted to focus on healthcare for American Indians, on education for American Indians, on gaming for American Indians, on the Arts and Craft Act, the Grave Protection Act, and the Indian Child Welfare Act, just to name a few. But there's a significant series of federal statutes that were enacted and remain in place today based on that unique political status that tribes have. When we look at the tribal state agreement, I'm using this stone structure here to show what we have. On the bottom here is the Indian Child Welfare Act, right? That's the absolute minimum federal statute that we all across the United States must adhere to within the state court system when we are working with American Indian families. Stacked on top of that is another set of guideposts for us, and that's the federal regulations. And those were revised in 2016. Many of you may have had an opportunity to participate in that. There were listening sessions all around the country, and including here in the Shakopee, Mdewakanton, and Sioux community hosted the Minneapolis listening session. And so many of us were there to provide our arguments and our wishes for what those regulations would contain. I'm quite proud that the regulations do reflect much of what Minnesota has enacted through our Minnesota Indian Family Preservation Act, also known as MIFPA. And that's the third stone here that stacks together to give us guidance in Minnesota anyway, with regard to working with Indian families when we are in the state court system. MIFPA was enacted in 1998 and it was revised substantially in 2008. It's been revised a number of other times throughout its history, but those are the two significant periods. Following MIFPA, the next layer of guidance for us is the TSA, or the Tribal State Agreement. It took many folks coming together over 5 years to develop the tribal state agreement, and that was enacted initially in 1998. Many of the folks that worked on that are still around. We have had a number of those elders that were actively involved with that have passed on already. But that was enacted in 1998 and was revised substantively in 2007 at the request of tribal leadership, because we were having difficulty with implementation and our practices had changed. And so we brought together players from all around the table to figure out what words to put on paper that accurately reflected how we were conducting ourselves and how we intended to conduct ourselves as we work with Indian families. The last layer that's here is local agreements, which are permitted through the Indian Child Welfare Act as well. And so many local tribes with the local counties will have their own local agreement that provides further guidance. Excuse me. With regard to the policy behind the Indian Child Welfare Act, I wanted to share these 3 key provisions because I think that they set up very well what you're going to hear from Shannon and Karl in analysis of the argument before the Supreme Court. This is the citations within the Indian Child Welfare Act set forth at section 1901. In paragraph 1, it's where Congress shall have the power to regulate commerce with Indian tribes. There was much discussion regarding that in the oral arguments. The second policy argument that was set forth in the Indian Child Welfare Act itself was that Congress, through statutes, treaties, and its general course of dealing with Indian tribes, has assumed the responsibility for protection and preservation of Indian tribes and their resources. The third provision I wanted to address is that tribes have consistently, since time immemorial, believed that there is no resource that is more vital to the continued existence and integrity of the tribes than their children. Many of you have probably heard that tribes are always looking back 7 generations, and they're also looking forward 7 generations to our grandchildren's grandchildren when making decisions and leading for our community and taking actions individually and in the collective. The legislative history is important. If you have not had an opportunity to read the legislative history behind the Indian Child Welfare Act, I encourage you to do so. Tribes across the country committed in a heartfelt way to share stories of what their experiences were within their families and within their tribes that demanded enactment of minimum federal standards so that courts could interact with families in a better way, because there was a significantly disproportionate number of Indian kids that were being removed from their Indian families and not permitted to have that ongoing relationship and continue with their relatives. And I use that relative term, as far as families, but as far as their tribe as well. Minnesota, when you read the testimony, you will see there's a lot of people that provided testimony from Minnesota. We are really well represented in the congressional testimony that was provided. And that concern from tribes has not abated. In fact, it's only increased. And we have evidence of that with a number of tribes that signed on to the briefing that was before the United States Supreme Court. Tribes are continuing to monitor very closely this collection of cases. And it's not only in the United States here, but tribes in Canada are also monitoring closely what's happening because they are concerned as well. I'll just close with repeating that there's no resource that's more vital to the continued existence and integrity of Indian tribes than our children. And that is the driving force for ensuring that we do all that we can to protect and preserve these minimum standards that are set forth in the Indian Child Welfare Act. On behalf of tribes, I've had an opportunity to listen carefully, to listen with an open heart, and to advocate zealously for tribes to preserve and protect those intimate family relations. And it's consistently stated over and over how important it is to maintain these relations. And tribes are acutely aware of their status as sovereigns, and that also is consistently articulated. With that, I will turn it over.
Thank you so much, Jessica. Next, we're going to hear from Shannon Smith and Karl Nastrom from the ICWA Law Center here in Minnesota. Shannon has served as the executive director since 2004 and has over 15 years of experience working in the field of Indian child welfare. She has provided direct legal representation to hundreds of families impacted by the child protection system in state and tribal courts, and has provided ICWA training to local and national audiences. Karl is a writer and analyst at the center, and after graduating from college and serving in the U.S. Air Force, he earned advanced degrees in law, creative writing, and education. Karl has practiced law in Minnesota, Alabama, and California, and taught math in public schools in Mississippi and Maryland. Welcome, Shannon and Karl. We're excited you're here.
Thank you.
Thank you. So I promise there's not going to be any algebra quiz today. No math stuff here. I'm only going to talk about the lead up to the Brackeen, all the broad overview that Jessica gave. I'm going to leave that alone, and I'm not also going to talk about specifically what the arguments were before the court, because Shannon's going to talk about that. I'm just going to talk about how we got to where we are. And that started in 2017 specifically. Over the years since 1978, when ICWA was enacted, ever since then, people have been attacking ICWA in different state courts across the country. But in 2017, down in Texas in federal court, for reasons that would be very complicated to get into, several people sued the federal government, not to say that some little part of ICWA was unconstitutional or that their rights were being infringed in a specific way, but they went in and said, ICWA as a whole, that bottom rock in Jessica's diagram, the bottom rock of ICWA is unconstitutional and should be struck down. So that's what, generally speaking, that's what's at stake here. The people that started that litigation in 2017 were three families who were said that they were being prevented from adopting a child by ICWA, that they had a child ready to go. ICWA stepped in, provided a barrier, and they weren't able to adopt. Now, in two cases, that wound up being absolutely not true. In another case, a third case that I'll touch on a little bit later, in a Minnesota case, that wound up being true because under Minnesota state law, a family member was the proper person to adopt that child, not the foster parents. So there were these families, and then there were three states, Texas, Indiana, and Louisiana. They all joined together and they sued the federal government in federal court in Texas and said ICWA should be unconstitutional across the board, strike the whole thing down. On the other side, because the federal government was sued, the federal government became a defendant in this case. But then there were four tribes that joined in to help the federal government, because as Jessica was saying, the tribes have, since before ICWA long before ICWA have acknowledged to have an interest in their children. So they joined the federal government to defend the statute. And so the case went forward through the federal courts with families and states on one side and the federal government and the tribes on the other side. That's how the arrangement went. And that went all the way up into the Supreme Court. The argument in the Supreme Court was set up in that same manner. In the federal court below, this played out from 2018 to 2021. It was a long litigation. Even though there wasn't a trial, it just took a long time because it's a very complicated set of issues. The families, the adoptive families and the states won the first round. So the tribes and the federal government appealed, and the tribes and the federal government won the second round. And then the families and the states appealed to the big full appellate court in the Fifth Circuit, which is the federal circuit that covers the state of Texas, where this was all happening. And the full appellate court agreed to take the case. and they heard the case, and they issued one of the longest decisions that I've ever seen in my life of practicing law. It was over a 300-page decision, and at the end of the day, there was no winner. It was a tie. And the legal effect of that means that the district court's decision is upheld, but there's no precedential value. Nobody else can say, hey, this is law. It's a very unique, especially in a complicated case like this, there usually is a winner, which led to the unique next step of both sides in this case, the states and the families on one side, and the federal government and the tribes on the other side. Everybody asked the Supreme Court to take a look at the case. And so the Supreme Court took the case. They granted their cert, that's what it's called, certiorari. They granted a writ of certiorari in February of 2022, and the arguments were just held last week. In the lead up to the oral arguments in the Supreme Court, there was a lot of briefing. An awful lot of people submitted briefs, and some of that, Jessica already touched on one of those briefs. Each of the main parties was able to submit their briefs, and that's mainly what was focused on in the oral argument, was what the parties had asked the court to do. But I'm going to mention just three here. One is that one of the briefs that was the side briefs, the amicus briefs, the friend of the court briefs that was talked about in oral argument, had to do with the states that asked the court to keep ICWA in place. There were 23 of those states plus the District of Columbia, and one of those is Minnesota. So that's significant for those of us who practice in Minnesota, that this state stepped forward with Attorney General Ellison's signature on the line and said to the court, please uphold ICWA. Another brief that's significant for this audience is the Casey Family Program brief, because one of the things that, as a functional matter, there might be 300 organizations across the country that want the court to uphold ICWA, but we can't send in 300 briefs. So an organization like Casey will write a brief, and then they'll ask for help with that brief, and they'll ask for support. And two of the organizations, there were 26 organizations that signed the Casey brief, and two of those were the Child Welfare League of America and the National Association of Social Workers. So for this audience, I think that's relevant that there was a voice on behalf of this profession that was speaking to the court through Casey, which the Casey brief was the most cited brief other than the parties' briefs throughout the oral argument, just because Casey has such a great reputation. So there was a voice that was raised up from different sides. And then I'm going to take my last couple minutes here and just talk about the brief that we wrote here at the Law Center for one of the families that was involved in the litigation to the Supreme Court. A woman named Robin Bradshaw, who is a White Earth member. Her granddaughter was a foster for the Clifford family, and the Clifford family is, remember I kept talking about these three families that have sued to invalidate ICWA. The Cliffords are one of those families. So Robin Bradshaw's granddaughter was involved, and the states, the families that were doing their government, never told the federal courts in Texas the whole story. In some regard, they told inaccuracies about what was going on with Robin Bradshaw's granddaughter. So there was no chance, because we weren't involved in the case in the federal courts in Texas, there was no chance for Robin Bradshaw to tell her story. But now that the Supreme Court was going to hear the case, there was a chance for her to tell her story. And it's the reason that we have to have ICWA, because Robin Bradshaw was, as soon as her granddaughter was removed from her mother's care, Robin Bradshaw went to the county and said, I'm the grandma. I've been raising this child since she was born. Her mom lived with me while she was pregnant. I'm the right person to care for her. She went the day that this girl was placed in care back in 2014. And the reason that this is a significant ICWA case is that there were some mistakes, some oversights on the county level that were not corrected until White Earth got involved, and the case was transferred into ICWA, so there was greater attention paid. The tribe was able to be involved as a party, and so the tribe was able to bring bring additional arguments and make additional points and have a seat at the table. And that had not happened prior to the tribe getting involved. So that we wrote a brief to explain to the U.S. Supreme Court that, hey, this is a case where ICWA was properly applied, and there was a full trial was held in Minnesota court by a state court judge over 5 days. Evidence was taken. The Cliffords came in and gave testimony. Robin Bradshaw gave testimony. Both sides had experts that gave testimony. Tribal elders gave testimony. You know, it was a full trial where both sides could call whoever they wanted to call to give the judge something to think about. And at the end of all of that, the judge said that this child, Robin Bradshaw's granddaughter, should have been with Robin Bradshaw from the start. That she should have been there all along. And it's a significant outcome because without ICWA, that trial might never have happened. That adoption might have gone through. We'll never know. But and then the facts were distorted in the federal courts to make Robin Bradshaw out to be someone that she was not. A negative facts were stated about her that weren't true. And so that was something that we did here in our office with obviously with Ms. Bradshaw's participation and with a law firm in California. There were several of us who worked on the brief to provide some personal details to counter or to supplement what Jessica was talking about and what Shannon's about to talk about, the big picture, high stuff, the constitutional arguments and the constitutional history. We provided some of the here's what happened in one family's life. So I'm going to stop with that. I'm going to pass it over to Shannon, who's going to complete this presentation.
Good morning, and thank you for the opportunity to talk about something that obviously I think for us on the call and from a social work perspective, from a legal perspective, being located in a state where we're at, that really matters in regards to how we do the work that we do. And I think why this matters, going back to what Jessica said, the 7 generations before and the 7 generations to come, that we have an opportunity to do the work that we do in a way that can have an impact. And so as the thing to kind of think about as we're talking about the legal aspect of this case, I know from a social work perspective, that is my background prior to going to law school, is that really what matters is the individual story, right? Like how that impacts the individual, how it impacts the community, how it impacts everyone around us, and why does that matter? And so I think in that context, even though we're talking about really kind of high level legal issues, I think the thing to pay attention to and the thing to really focus on is how does this impact children? How does it impact families? How does it impact tribes? And how can we do this in a way that is right? So the big picture constitutional challenges. First of all, I think it's really important, and I know this has been touched on a little bit, but to understand kind of who the plaintiffs are and who the defendants are. The plaintiffs in this case, as I think both Karl and Jessica mentioned, are the state of Texas. As we things evolved, the state of Texas was the only state that continued to move forward. So we have the state of Texas, and then we have the 3 individual plaintiffs that kind of collectively were are talked about as the Brackeens. So that is 2 families that were able to adopt children. And then the Bradshaw case, which where grandma ultimately adopted her granddaughter. For the defendants, we have the federal government, so the Department of Interior, and then we have the tribes. And as we kind of think about how this works and why it matters, I think one of the really important things, again, kind of going back to the idea of like stories and controversies, that as the legal system is set up, that it's really an important aspect and kind of foundational piece of our legal system is that the judges
whether it be at the Supreme Court, whether it be at state court, district court, the judges are deciding things that are real controversies, right? Like there's something that they can do in order to remedy what's going on. And that there's something that there's a controversy or there's a decision or conflict that they have the ability to decide, and that their decision will have an impact on the people that are appearing in front of them. I think that's one thing just to kind of hold on to as we're talking through that. I think it's something that is an issue in this case, to really kind of think about the fact that, for example, for Robin Bradshaw and the Cliffords, that the Minnesota courts have already finalized the adoption. So, what the Supreme Court does, I think arguably will have absolutely no impact on specifically on these families. And I think that's also true in the other cases where adoptions have been finalized. So just kind of thinking about that in context and why this is important, and why this kind of decision by the US Supreme Court to even take and hear this case is somewhat unique, and something to really kind of think about what that means for for future implications. There are really three, some maybe four, but three constitutional arguments that I'm going to talk about or kind of highlight today. One has to do with equal protection. One has to do with the federal government's relationship with tribes as sovereign nations, and one has to do in regards to the relationship between federal government and states. And those are kind of the big three issues. And there's different terminology that's used. And I'll kind of go through that. But as you're thinking about kind of the complexity of this case and some of the constitutional issues, really those are the three that are being talked about the most, and probably have the most significance as things are moving forward, and kind of watching what the Supreme Court does with that. So the plaintiffs, so the state of Texas, and then the three individual families, they are arguing, one, that the federal government does not have the the authority, the power by the Constitution to enter or to act on behalf of tribes. So that this relationship, these promises in regards to the sovereign to sovereign relationships, government to government relationships, this idea that the federal government has a promise to protect, to move forward in a way that tribes continue to exist, and to honor and acknowledge and protect that, that doesn't exist. So that's one of the plaintiffs' arguments. Another argument of the plaintiffs is that the entirety of the Indian Child Welfare Act is really premised on race, and not based on the fact of Indian children being members, being enrolled, being citizens of tribe. That really what this is about is a race-based law. The third argument of the plaintiffs is that by the federal government enacting or passing the Indian Child Welfare Act, that they're telling the states to do things, or compelling the states to act, state actors to do things or be required to provide things like active effort. So that's really kind of the sense of where the plaintiffs are coming at. So holding on to those three, now talking about what the response is and why these matter from the defendant's perspective. So again, recognizing the defendants are the tribes, recognizing that the defendant is the federal government through the Department of Interior. And the argument from the defendants is that absolutely Congress has the ability to pass laws connected to Indian tribes through plenary power. This idea that there is this unique relationship between the federal government and the tribes, and that is a relationship that was started, a relationship that was valued through treaties, and that power and that intent, that there was a very deliberate engagement between tribes and the federal government, that tribes had inherent
Hey, Shannon.
Yep, I'm seeing that. I will turn off the videos.
Thank you.
Yep, let me know if this is not better. That there is a relationship between the federal government and the tribes. And as part of that relationship, as part of that that promise to recognize tribal sovereignty, that in fact ICWA is a part of that. So that's one of the arguments. The other argument is that this really is not a race-based law, that this law is based on the fact that Indian children are members of sovereign nations, that they are maybe enrolled, that they're recognized as citizens, that they are really the future of tribes. And going back again to what Jessica said, that they're the most important, the most valuable resource, and that in order for tribes to exist into the future, that children are absolutely are the most important thing, right? Like tribes aren't going to continue to exist if the children are taken from them. And so recognizing that the unique status, that this is really a political status, it's a relationship between tribal children and their tribe, and that is something that is valuable, is protected, and that as citizens of tribes, as members of tribes, that they have this unique relationship to this political status. And so that it's not a race-based law, but really it is based on their unique status as tribal children. And then finally, in regards to commandeering, the idea that that through the power of Congress to be able to pass laws, some of those very laws that Jessica said, healthcare, education, that they should also have the ability to pass laws such as the Indian Child Welfare Act that allows and indicates the importance of preserving families, the importance of providing active efforts in order to keep families together, to respond to families, and to provide a meaningful response to their needs. So those are the arguments of the defendants. So we have kind of these two different sets of constitutional arguments, and those were things that were talked about to some extent at oral arguments, and the recognition of the importance of these arguments really for the future of tribes, right? Like, I think that's one thing to really pay attention to, is that this unique relationship between the tribes and tribes as sovereigns and the federal government, that absolutely that has an impact in regards to kind of the entirety of Indian law, and how important it is that if recognizing, you know, really what's at stake in regards to Indian children. There was a lot of conversation at the oral argument, or during the oral argument, about best interest and what does that mean. And I think ultimately one of the attorneys for the tribe, you know, really was clear in the idea that when the Indian Child Welfare Act was passed, that it was passed with the intent and with the really the vision of so many people who had testified as to the importance of the Indian Child Welfare Act as being the best in Indian children, that for Indian children staying connected to who they are, being connected to their tribal community, being connected to their families, that ultimately the Indian Child Welfare Act and complying with this spirit and the, you know, the mandates of the Indian Child Welfare Act is what was needed in order to protect the best interests of Indian children. And so that was an argument that there was a lot of talk about kind of how does that look and what does that mean, and the ability of tribal people, of the, you know, for qualified expert witness to provide impact and opportunity to share with the court the importance of how we can do this in a way to ensure that all decisions truly honor a child's identity, they truly honor a tribal perspective in regards to making sure that children are safe, that they're cared for, and that in no way does the Indian Child Welfare Act compromise best interests. Instead, it really upholds what is best, and that there's an opportunity to do that. So that kind of back and forth is something I think is really important to kind of pay attention to, and recognizing the value of compliance with the Indian Child Welfare Act in regards to recognizing the voice of tribes, and that really the children are absolutely the future, and honoring and protecting them and holding them up as the most important aspect of the future is absolutely an opportunity that the Indian Child Welfare Act provides. I think one of the things, you know, in regards to kind of the complexity of the arguments is who gets to assert what is best for children. Is it the tribes? Is it the parents? Is it, you know, a prospective adoptive family? And I think that is something that came up in regards to how the court was kind of looking at things, and that came up in the context of standing. And is there, you know, who is bringing forth the voice of the children? And certainly from, you know, the defendant's perspective, that absolutely needs to be brought forth from the tribal perspective, from the perspective of children's families, and making sure that that those connections are honored and protected.
Thank you, Shannon. And if anybody in the audience has any questions, feel free to use the Q&A function. If Jessica, Shannon, or Karl have anything additional that you'd like to add, we do have a few minutes. We'll give it a minute here to see if there are any audience questions, and otherwise we'll move on to our next speaker. Shannon, Karl, or Jessica, if you see the question and you'd like to answer it, go ahead.
So the question, go ahead, Jessica.
So the issue of race versus political status is a big issue. And that is, in my opinion, that's what this whole case turns on. Oftentimes what in my experience, I think that folks that don't understand Indian tribes and don't understand the relationship that's unique between the federal government and each of the over 500 federally recognized tribes. If you're not working in that area and you're not, you know, you didn't have an opportunity to learn anything about that, it's very simple to say, and it's very common to say, well, this is race. It's all it is race. American Indians are a race, African Americans are a race, and so this is a racial classification, and therefore we have a good challenge here to move forward with this case. And the argument that the plaintiffs are using, as you've heard from Shannon and also from Karl, they're saying that Indians are a race and it's not fair to make a law that allows one race to have preference over another race, is the most simple condensed argument that I can take from it. The reality, though, is and that's what I said at the outset, this is not a race-based classification. It's a political classification because of that unique federal government to tribal government relationship. I mean, the federal government can't enter into treaties with the African-American community. They can't enter into treaties with the Hmong community. They can't enter into treaties with, you know, any of the other, you know, racial categories or classifications. I have an opinion about, you know, if other communities should also, other communities of color should also have an opportunity to have some of the approach that is used in the Indian Child Welfare Act in each of the communities. I obviously have a personal opinion about that, but legally there is a significant difference because of our political relationship with the federal government. I hope that goes to the question that was presented, looking at how race is being used by the plaintiffs. If you want to follow up with more questions to help me get it right, I would appreciate that. And then Shannon, you had something to say as well.
Thank you, Jessica. You covered it perfectly.
And we probably have time for about one more question. Shannon, Karl, Jessica, if you want to check out the questions, and probably about 2 or 3 more minutes. I can read it for you as well, if that's helpful.
Sure.
Okay. So I've seen Native American children be returned to their abusive parents for more trauma, citing ICWA. Is it equal protection?
So I think, I guess in regards to this question, I mean, I think that, you know, a piece of the child welfare system as a whole is based on decisions made by social workers, decisions made by judges, decision made by all of those involved. There is absolutely nothing in ICWA that would compel a child to go home to an unsafe home. And ICWA, there's provisions in ICWA in regards to the, you know, if there is a need for an emergency placement, that absolutely can happen. Because it is a system that is a human system, oftentimes along the way, there may be, you know, social work, an attorney, a judge that is making decisions and trying to assess, you know, assess safety, assess decisions that are, or assess, you know, situation of the family. But in regards to the law, there is absolutely nothing in ICWA that would compel or indicate in any circumstances that a child should ever be placed in a situation where their safety is compromised.
I think one thing that I would add to what Shannon has shared is, and it goes to, I can see another question here with regard to making decisions about child's welfare and well-being. One thing that's really important about this law is it looks at the child's best interest over a long time, right? Over their lifetime. It doesn't take just the snapshot look at in the 6 months what's in the best interest. It takes a longer view. And I know that sometimes seems like a distinction without a difference, but in application of Indian Child Welfare Act cases, that really is a significant deal because we have so many data sets and anecdotal stories that affirm that when children are adopted out, regardless of how much love and goodness is shared, if they are adopted out by a non-Indian family, those children typically, as they become teenagers and as they become adults, have significant consequences that come their way. They have a really difficult time finding themselves and identifying who they are because they haven't had the support and that natural system of knowing who they are and knowing how their relationships are interwoven with their extended families. And that is a really big component to the Indian Child Welfare Act. And so maybe that goes to a little bit of what the prior question was speaking to. And then go ahead.
Oh, are you going to answer the next one, Jessica?
Go ahead.
You can go.
Well, just speaking about making the decisions for the child's welfare, it is intended under the federal statute to defer to the tribe, because the way the congressional testimony was received and what Congress was intending is Congress was preferencing or preferring that tribes make the decisions. So that's why we have the transfer of jurisdiction language in there, where cases are intended. There's a presumption that they get transferred to the tribal court if that request is placed in the district court proceedings. And then there are provisions, as you're well aware, under the Indian Child Welfare Act, where we defer to the tribes and we expect that the cultural values and norms of that Indian child's tribe be applied when working with any particular child. And so it is true that having the child's tribe participate and make those decisions and lean toward that is what's preferred. Shannon?
I'm going to answer this really quick. There's one more question. I think that they want us to get to plenary power. So as quick as I can do this, because I think we have like a minute, but one of the things is that the way kind of the Constitution works as a whole is that in order for the federal government to enact a law, they have to have a basis, or they have to have something in the Constitution that allows or enables them to do that. And plenary power is a specific provision or specific kind of concept in the Constitution that basically allows the federal government to enact laws to safeguard, to in relationship to Indian tribes. So as a sovereign, the recognition that tribes had a unique political status, a unique sovereignty, and that they were here prior to the Constitution. And so that unique status allows Congress to enact laws in a way that is different in other communities. And so it's really the sovereignty of the tribes and that government to government relationship. And it is plenary power is kind of this in the Constitution, what allows federal government specifically to act in relationship to sovereign tribes.
Okay, thank you, Shannon and Jessica and Karl. There are more questions, but as we said, we have limited time. So if we're able to get to them, type back to the audience member, we will. Thank you so much for submitting questions, and thanks to Shannon, Jessica, and Karl for getting to some. So we are going to move on. We have a couple more speakers today. Next, we're going to hear from Reanna Jacobs and Cindi Miller from the Minnesota Department of Human Services American Indian Wellbeing Unit. Reanna is a manager and Cindi is an ICWA compliance consultant. Welcome, Cindi and Reanna.
Thank you.
Yes, thank you. So I'm going to share my slide here. Can everyone see the slides? I'm getting a thumbs up, I think, from Jessica. Thank you, Jessica.
Yep, it looks good, Reanna.
Thank you. All right, so the American Indian Wellbeing Unit, Cindi and I'm just going to introduce myself. My name is Reanna Jacobs. I'm a member with CASCW, the Lower Sioux Indian community here in Minnesota. And previously to working at the Department of Human Services, I worked for CASCW as an ICWA advocate and a plethora of other jobs, from licensing foster parents on reservation, managing federal, state grants, as well as chemical dependency counseling. So happy to be here, and I'm going to let my colleague introduce herself.
Good morning, everybody. My name is Cindi Miller, and I have worked, prior to coming to DHS, I worked in the family law and child welfare areas for about 20 years. Been at DHS since 2018, and prior to that, I worked for the Mille Lacs Bennet Ojibwe as a tribal initiative attorney and also as an attorney in their tribal court. And like Reanna, I'm an enrolled member of the Lower Sioux or Chanseyape community. If you're interested, Chanseyape in Dakota means where they paint the trees red. So take it away, Reanna.
So I'm just going to start with a basis, kind of help frames like the work that we do here in Minnesota. So the administrative framework for child welfare services and programs, it varies from state to state. And all states, are responsible for compliance with federal and state requirements. However, they may differ in the way child welfare services are operated and delivered. So here in Minnesota, which is one of 12 states nationally, we operate as a state supervised county administered child welfare system. And this functions where DHS assumes the responsibility of federal and state compliance, but sets program requirements, through issuing of policy, and we oversee county implementation of policy, such as the Minnesota Indian Family Preservation Act, also known as MIFPA, and Jessica briefly went through that when she went through her rocks. I loved the rocks. That was so fundamental and so like concrete at the same time. So I love that. Thank you, Jessica, for sharing that. So what really guides our work here at at the state in terms of Indian children and child welfare is ICWA, MIFPA, and our tribal state agreement. Really want to focus though on the Minnesota Indian Family Preservation Act, MIFPA, and the intent is to protect the long-term interests as defined by the tribes and their family as defined by law or customs, and to preserve the Indian family and keep them together. And while preserving the Indian family, tribal identity is preserved, including an understanding that Indian children are impacted negatively if family and child, the child's tribal identity are denied. Indian children are the future of tribes and are vital to their existence. MIFPA is only applicable to cases here in Minnesota, but expands and it strengthens on the Indian Child Welfare Act provisions. An example is MIFPA sets a specific standard of what active efforts looks like, whereas ICWA is very broad in its definition. Additionally, we have components to MIFPA that establishes an American Indian Child Welfare Advisory Council. And this council is made up of 11 representatives from the Minnesota's federally recognized tribes, as well as 6 Indian urban representatives who are seated by the department's commissioner. And this body of folks or individuals make recommendations and provide guidance to the department on policy and legislation that may impact American Indian children and families. Key to this SCOTUS argument is the basis in which the decision is made. If the Equal Protection Law is a basis for the federal law being repealed, MIFPA would most likely equally be repealed. However, if it is based on the anti-commandeering, which Karl and Shannon briefly spoke about, if that is the basis or the decision, MIFPA will remain, and the state has the authority to amend and strengthen. And so there's some work happening, and I will hand that over to my colleague, Cindi, to speak more about what Minnesota is doing in terms of the what ifs and the decisions.
So I'll just tell you a little bit about the ICWA unit, which is now called the American Indian Wellbeing Unit, which we recently renamed because we have gone from, I think, 4 people in 2018. We're up to now 10 staff. So we have, obviously we have ICWA compliance consultants. I'm one of those, but we also have equity policy consultants, several people who work with the initiative tribes in Minnesota, of which there are 3. a prevention and early intervention consultant, and then we have an ICWA SSIS training coordinator. So the questions come up, well, what are we going to do if ICWA is repealed? Worst case scenario. You know, we're still going to have grants that will be available to tribes and other American Indian agencies, including such things as whole family system grants, which address systemic influences related to racial and economic inequities. And there'll still be continuous quality improvement in place and the Families First Prevention Services Act in place, which changes the way child welfare services are provided in Minnesota and establishes placement prevention services to strengthen all of our families, not just Native American families. We have also been in communication with the DHS General Counsel's Office to discuss options for what happens if ICWA is repealed. At this point, as you know from listening to today's discussion, it's speculative right now because we don't know what's going to happen, but we remain committed to planning as much as we can. I am involved in an external MIFPA work group that includes tribal reps, attorneys, and DHS. We've been working on writing amendments to MIFPA and to incorporate more of ICWA into our state statute, as well as revising some provisions to make them more consistent with Minnesota ICWA and MIFPA daily practice. We have also been involved, our unit, in educating others about how important this case is, and including some of our colleagues at DHS and other folks outside of DHS. We even had, I believe, 3 of our staff people from the unit attend the oral argument last week in Washington, D.C. So we're anxious to see what they have to say about their experience, as we haven't had a chance to get together with them. But as Reanna said, protections under MIFPA depend on what happens with the outcome of this case. And if ICWA is found unconstitutional on equal protection grounds, which is the worst case scenario, then other state ICWA statutes are in trouble. But I think that's all I have, unless anybody has any questions or comments.
So we did provide our PowerPoint to Stacy. So if other folks are interested, we do have a resource site, so you can see where we have an Indian Child Welfare Manual, which incorporates MIFPA. We also have caseworker checklist or guide. We also have non-compliance reporting, and so all of that work would be shifted, but we do have a resource list if you are interested. So Pidamia is thank you in Dakota.
Thank you, Reanna and Cindi. And yep, we can send out that PowerPoint. We will be sending out a recording of this webinar to all registrants, as well as post it on the website. So with that, we will attach the PowerPoint. And then before we do move on to our final speaker, Shannon and Jessica have agreed to answer some of the questions that we couldn't get to in a recorded kind of addendum webinar. So we can also send that out to the audience members, if that would be helpful. There's about six or seven questions. So that way we won't run out of time here, and that hopefully folks can get some of those answered. And thanks again for your time and willingness to do that. So we are going to move on. We have our final speaker for the day, and we're going to hear from Justice Ann McKeig of the Minnesota Supreme Court. Justice McKeig is the first female American Indian appointed to the court. She's deeply involved in child welfare and domestic violence issues, as well as tribal community issues. We're so excited that you're willing to join us. Welcome, Justice McKeig.
Bonjour, good morning, everyone. I'm really excited to be here with this outstanding panel. I hope you guys have found it really interesting, because it's an interesting issue. And I'm just here to give you a little bit of perspective about what might be happening. For those of you who have listened to the argument, good for you. And for those of you who have not had the opportunity, you can actually listen to the argument. It's about 3 hours long. I've listened, I'm only 2 hours in. It's a long argument. It's very complicated. It can be very confusing, but I encourage you all to take it in bits and pieces and try to listen to it. So it's a very confusing process, I think, when one sits and waits and tries to figure out what the court is going to do. So generally what happens is they're very similar to how we operate at the Minnesota Supreme Court. You will have all of the briefs that are filed with the court. Each of the justices has anywhere, I think, from 4 to 6 law clerks who will help synthesize all of that information. They may even put it in sort of a bench memo form that goes out to all of the justices so that they are really prepared for oral argument. And in the couple of hours of argument that I listened to, it seemed to me that the justices were very engaged and that they had clearly done their homework and had a really, I think, good understanding of the issue that was before the court. Once they are prepared for oral argument, they all go in, and we always say that a hot bench is a good bench. It means that the court is very interested in the issue, and you will sort of start to get bits and pieces of people's perspective. For me, the person that stood out the most was probably Justice Gorsuch. He has hired the first Native American law clerk on the United States Supreme Court. He is considered a friend to Indian country. He asked a lot of questions of the state attorney general for the state of Texas. He also asked a lot of questions of the parents' attorney. I felt like the tone of his questions and the passion with which he asked them told me that he is going to be on the side of upholding the Indian Child Welfare Act. It even appeared to me that he was, I don't know that angry is the right word, but I could tell that he was very frustrated by some of the positions that were being held by counsel. And for those of you who listen to it, you may have noticed that there's a lot of perhaps even interrupting of counsel as they are trying to answer questions. And that's not uncommon. Part of that is just the court wants to get to certain information and they want an answer and they want a direct answer. And sometimes lawyers will try to weave their way around. I know for us as well, when lawyers don't answer the questions directly, we may interrupt them and say, that's not my question. I want you to answer this, trying to really pin down their position. A lot of other questions were asked by Justice Thomas, which is somewhat unusual because he is known for not asking very many questions, if ever. Most of the time he is silent during oral argument, and he actually posed, in the time that I listened to, I want to say 4 or 5 questions, and that's highly unusual. I couldn't tell by the questions that he was asking where he may come down on this. Justice Sotomayor asked a number of questions. I'm pretty confident in her looking at her voting history that she will uphold the Indian Child Welfare Act. Of course, I could be wrong. Justice Kagan asked a few questions. Justice Jackson, who is the newest justice of the court, also was very engaged in asking a lot of questions. Justice Amy Barrett asked a few questions, and Justice Kavanaugh asked, I think, only one question at the point that I had to stop listening. Now, I suspect there may be more questions from some of the justices who asked fewer questions posed to the tribe attorney who had just gotten up and started to make his argument. So after oral argument, generally the court will convene as a court, and they will start discussing the case and come up with a decision. And generally how that goes is somebody sort of presents the facts, presents the issues, and may even have a recommendation for the court. When they meet, it is only the justices. It's a very confidential process, and there's a reason for that. As you all may have seen what happened when there was a leak of the court, which is a highly unusual occurrence and can be quite problematic because we want the justices to come up with a decision without outside pressure. However, as you can imagine, they sort of have to put your head in the sand and focus on the issues and the arguments before instead of everything else that's going around or around you. But once they meet, they negotiate, there may be the recommendation given by one justice, and then they'll go around in order of seniority. And they will say either whether they agree with that position or disagree with that position, or they may ask further questions about what is being proposed. And then you sort of see where the vote lies. Sometimes if there is room for negotiation on an issue, one of the questions I saw asked was, could they issue a very narrow decision or could they do a sweeping decision? Most of the time the court enters very narrow decisions, but they could go extremely broad and just say the act is unconstitutional, or they could say it's not, or they could carve out certain aspects of the Indian Child Welfare Act and address it in a different way. So there's a number of things that they can do, but even sometimes in the writing, things will change. So you'll have a majority author, and then you will have dissenting author or authors. And then there may be somebody who wants to write a concurrence because they want to make an issue clear or their position clear to those who are going to be reading it. So they may write something where they agree with the majority, but they want to make a separate point that the majority is not making. And then sometimes when that is written, people will look at it and they'll either be convinced to change their vote, or there may be some sort of behind the scenes negotiation between a couple of the justices to say, if you could add this language or if you could take this out, then I will get on board. And that can delay the time in which it takes to put an opinion out, depending on the thought process of the court and depending on how split they are. I know that one of the questions was asking the panel how we think this is going to come out. And boy, that's a really tough question. You know, if I were a betting person, which I'm not, I frankly hope very much that the court is going to uphold, well, I shouldn't say hope. I think they're going to uphold the Indian Child Welfare Act just by the questions that were asked, but I could be completely wrong. It's really hard to try to figure out where certain justices lie. Sometimes you're able to tell by the questions, like, for example, Justice Gorsuch, I have no doubt that he is going to come down on the side of upholding the Indian Child Welfare Act just by the questions that he asked. So it's going to be very interesting. Sorry, that's my dog. Who knows how long it'll take. I'm going to pause myself for a moment. If there is any questions, please let me know. I'm going to let my dog outside for a moment.
Thanks, Justice McKeig. I do see a question, where would I find the oral argument so I can listen to it? If any of the panelists have a good resource for that, otherwise we can also put that in the email out to folks as well.
My apologies, everyone. This is what happens. The dog's been gone. And then the minute I'm talking, the dog comes in and then has to have, you know, raise hell kind of hell. I will post in the chat where you can listen to the argument. You can't see it, which is too bad. I was really hoping that they would have the ability for us to actually watch it and watch the justices as they pose the questions, but it's audio only. And I want to say that I think it's 3 hours and 12 minutes, but I will post that in the chat so that people can easily find the argument. And I don't know if there's any other questions that I can answer, or perhaps there are some of the questions that have been posed that haven't been answered. Let me just look quickly.
Justice McKeig, this is Tracy Laliberty. Do you have a sense, I know rulings take all kinds of different times for all kinds of different reasons, but do you have a sense of what the wait time on this might be?
Boy, if I had to venture a guess, I would say probably 5 months would be semi-typical. You know, the longer it waits, I mean, I will say that for our court, decisions that have taken up to a year is generally because there is a lot of people changing their mind on issues. I'm not so sure that this is going to be one of them, although, like, as was pointed out, the decision from the circuit court was extremely long. It's the longest decision I've ever seen. So there is a lot to weigh through, although there's a finite number of issues that the court will address. But if I had to venture a guess, I would say about 5 months.
And one thing I think folks might be wondering too is once the ruling comes down, however that might fall, what comes next? What is the timing of implementation if there's a change, or I guess if there's, you know, a positive ruling, then there wouldn't be a time afterwards. But what can you just help people understand what happens after?
Yeah, once the decision comes out, the court will give some guidance about implementation, but then really it's going to be up to the state attorney generals, perhaps the Department of Justice, along with the Bureau of Indian Affairs. Maybe they're going to be putting out new guidelines. It really depends on how the court comes out, but sometimes there isn't much guidance and it just becomes really confusing, and then it's going to be up for the states to implement whatever it is that we think the United States Supreme Court has said. I know that's probably one of the greatest frustrations by practitioners, even from our court, is that they think we don't perhaps give enough guidance about what's to happen next. So it's really going to depend on the language in the opinion, but then it'll be a hot discussion and hopefully more panels like this to talk about what does it mean now that the court has actually made a decision. And I don't know if anybody else wants to weigh in.
Okay, great. I think we have time for one question here that any of the panelists are welcome to answer. So besides raising awareness while we're waiting for SCOTUS decision next year, what can Minnesotans do to support MIFBA, tribal programs, or efforts preparing for the quote, what ifs around the decision?
So this is Reanna with Department of Human Services, and I would say speak up, being an advocate, right? I know there's some movement to move some legislation, and so being familiar, you know, with that legislation and speaking up to your legislators and being an advocate in support of tribes, tribal, urban Indian organizations. There's always like a meet and greet that comes up. Be active, take an active role in those Indian urban communities to support or be an ally.
Thanks, Reanna. Any other closing words or final thoughts specifically around efforts preparing for the what if decisions?
I'll echo what Reanna has shared with you. And then I also want to leave with a message of hope, because when I first started practicing law, I worked on behalf of the Grand Portage Band, and there's an old woman up there that was really clear with me that one of the values is to always have hope. As long as there's breath, there is hope. And so I often remember Cheryl Kelpie's words, and it's at times like this where, you know, there's a lot of uncertainty. Things could really go backward in time significantly, depending on the decision that comes from the Supreme Court. So I'm going to try to have hope and stay in that good place. But I also agree with what Reanna has suggested. Let's plan. Let's be ready for what might come our way, and having relationships with your elected officials so that we are able to have laws passed locally that can protect and can ensure that this approach is utilized in a good way, and honoring and respecting that unique political relationship is really important. And then continuing to support the programs that are doing the hard work. It's really hard to be a social worker. There's a lot of really great rewards that come from it, but it's also a really hard job. And so being able to support one another in a way that helps meet families where they're at and helps them transcend to a place of balance, that's good work. And that's how we keep families together. And that's what this law intends. It starts from a place of keeping families together. It doesn't start from a place of let's try to reunify. It starts from we've got this family. There's some needs. What can we do to help them find balance? And so just encourage you, if you can put that into practice in that way, that would be a positive thing to do until we have the results, and even after the results of the findings by the court. Thank you. And thanks for everybody being here today.
Thank you so much for that, Jessica. I don't know that we could end any better than with what your final words were. I also want to thank everybody for being here today. We had a terrific response when we first put this forum out for registration, and I think it is because people, are so committed to understanding, what is happening, what were the arguments, what are the underlying legal complexities. So I extend my thanks to all of our panelists and to the CASCW staff, of course, for being able to bring us this forum and to be able to facilitate it in a way that is accessible across the state. And I think we have folks from other parts of the country that have also tuned in. We will, as Stacy has said, we'll be posting this recording, and then for outstanding questions that weren't answered, we will get those answers in a video format, and we will post those as well, as well as, the DHS slides and other resources. So please look for those in a mailing. Please send us your feedback if you have feedback for us in any way, shape, or form. And CASCW will continue to follow the SCOTUS decision and be bringing information to people as it's made available. So thank you very, very much. And again, thank you to all of our speakers. Have a great day.